The morning sun filtered through the tall, arched windows of the federal courthouse in downtown Denver, casting long shadows across the polished marble floors. Judge Harrison Mitchell arrived at his chambers precisely at 7:45 a.m., as he had done for the past 18 years of his judicial tenure. His assistant, Margaret, had already prepared his coffee, black, no sugar, and laid out the case files for the day in neat, organized stacks. Today promised to be routine: a drug trafficking prosecution that had already been delayed twice, a civil dispute over property lines, and a sentencing hearing for a white-collar crime conviction. Nothing particularly novel or challenging on the docket. By 9:30 a.m., Judge Mitchell had taken his seat on the bench, his black robes draped precisely over his shoulders, his silver hair combed back with meticulous care. The courtroom was moderately full, the usual assembly of court staff, attorneys, defendants, and curious observers who enjoyed spending their mornings watching the machinery of justice turn. The courtroom had the distinctive smell of aged wood, leather-bound law books, and the faint mustiness that accumulated in any room built to last centuries. Judge Mitchell had grown fond of this smell. It represented stability, tradition, and the weight of judicial authority that he carried with considerable pride. The first case was called United States v. Marcus Wellington. The defendant sat at the prosecution's table, a thin man in his early 30s with a nervous disposition, and a public defender who looked equally exhausted by the burden of a losing case. The evidence was straightforward. Wellington had been arrested during a vehicle stop in which approximately 15 kilograms of cocaine had been discovered. The prosecution was confident, the defense was struggling, and Judge Mitchell expected a quick conviction followed by sentencing. As the prosecution began laying out their case, the lead prosecutor, Assistant U.S. Attorney James Blackwell, stood and made his opening statement. Blackwell was competent, articulate, and had won 73% of his cases over the past 5 years. He spoke with the measured confidence of a man who knew his evidence was solid. He detailed the stop, the search, and the discovery of the narcotics. Then came the line that prompted Judge Mitchell's first visible reaction. "Your Honor, the evidence was discovered as a result of an alert from K-9 Officer Duke, a German shepherd with a stellar record of 247 successful drug arrests during his 8 years of service with the Denver Police Department." Judge Mitchell's eyebrows rose slightly. He set down his pen and allowed a small, knowing smile to cross his face, the kind of smile that suggested private amusement at something only he fully appreciated. His law clerk, a bright young woman named Jessica Torres, fresh out of Yale Law School, noticed the shift in his demeanor immediately. She had worked for Judge Mitchell for 14 months and had learned to read his moods like a courtroom transcript. The judge glanced toward his courtroom clerk, a man named Robert Santos who had worked in federal court for 32 years and had processed thousands of cases. Judge Mitchell raised his eyebrows in a gesture of subtle skepticism, and Robert, who understood the judge's personality intimately, suppressed a smile. The two men had developed an understanding over years of working together, a shared worldview that emphasized the importance of hard evidence, scientific testimony, and the fallibility of witness accounts. In their shared perspective, a dog's sense of smell, however developed, seemed like precisely the kind of squishy evidence that juries might find persuasive, but that a rational jurist should view with considerable skepticism. The smirk on Judge Mitchell's face deepened into something approaching quiet amusement. He had handled cases involving K-9 units before, and he had always maintained a certain intellectual distance from the hype surrounding police dogs. In his view, the reverence with which law enforcement spoke about their canine partners bordered on the superstitious, a kind of modern-day mysticism that had no place in a courtroom bound by rules of evidence and logic. "A dog," Judge Mitchell muttered under his breath, just loud enough for Robert to hear. Robert's eyes widened slightly. He knew that the judge had essentially already made up his mind about the credibility of this evidence, and they hadn't even heard from the dog yet. Jessica Torres shifted uncomfortably in her seat. She had been raised around dogs, had worked as a volunteer for an animal shelter during her undergraduate years, and had developed a profound respect for their cognitive abilities. But she said nothing. Voicing disagreement with Judge Mitchell would be inappropriate and professionally unwise. In the gallery, scattered members of the public sat with their phones, their coffee cups, and their varied levels of attention to the proceedings. A retired couple sat in the third row. The man had once worked for the Postal Service and had his own opinions about dogs. A young woman with blue hair sat taking notes. She was a paralegal for a nonprofit organization interested in K-9 policy. And Officer Sarah Chen, Duke's handler, sat in the back of the courtroom, her posture rigid, her jaw set. She had brought Duke in from the vehicle, where the dog was secured in the specially designed K-9 unit. She could not hear Judge Mitchell's dismissive comment, but she could sense, through years of training in reading people and their body language, that the judge's reaction to the mention of Duke's credentials had been tinged with skepticism. Judge Mitchell continued reviewing the case file before him, occasionally making notes in his precise, lawyerly handwriting. His notes were not about the substance of the evidence, but rather reminders to himself to scrutinize the K-9 testimony with particular care. He had, in his own mind, identified what he considered to be a weakness in the prosecution's case, and he was already preparing questions that would, he believed, expose the unreliability of using a dog as a detection mechanism. The courtroom settled into that particular kind of quiet tension that precedes significant testimony. The fluorescent lights hummed their constant, almost inaudible song. A court stenographer sat ready to record every word. The defendant, Marcus Wellington, stared straight ahead, his fate now in the hands of a judge who had already begun constructing a narrative in his mind about the limitations of the evidence against him. Judge Mitchell took a sip of water from the glass on his bench and allowed himself another small, satisfied smile. He was looking forward to this testimony. He was looking forward to demonstrating, through careful cross-examination, that relying on a dog's instinct was precisely the kind of lazy thinking that undermined the integrity of the judicial system. He had no idea that within hours that smile would fade completely, replaced by something far more uncomfortable, genuine, profound embarrassment. The courtroom doors opened precisely at 10:47 a.m., and Officer Sarah Chen entered with the measured, professional stride of someone who had testified in courtrooms dozens of times before. But she was not alone. Walking beside her, his leash held with practiced precision, was K-9 Officer Duke, a German shepherd whose physical presence immediately commanded attention in ways that transcended the typical authority of law enforcement. Duke was magnificent. At 87 pounds, he carried his weight with the muscular efficiency of an athlete in peak condition. His coat was jet black with rich tan markings that seemed to shimmer under the courtroom's fluorescent lights. His ears, alert and positioned forward, swiveled slightly as he took in the unfamiliar environment of the courtroom. His dark, intelligent eyes moved across the space with the kind of observant awareness that suggested a mind constantly processing information. But it was his presence, the subtle aura of trained discipline and purpose that surrounded him, that caused several people in the gallery to straighten in their seats. Judge Mitchell's expression did not change materially, but his fingers stilled on the bench. He watched as Officer Chen guided Duke to the space designated for witnesses, though Duke obviously could not take the stand in the traditional sense. Instead, Chen positioned herself and the dog in a designated area where both could be seen clearly by the judge, jury, and courtroom observers. A bailiff approached with the Bible, and Chen placed her hand on it, swearing to tell the truth. The entire moment carried a certain theatrical quality, the presentation of credible evidence by a professional who knew exactly how to present herself and her partner in the most persuasive light. Assistant U.S. Attorney James Blackwell rose from his seat and approached Officer Chen with the confidence of a prosecutor about to present undisputed evidence. He began with the foundational questions: her name, her position, her years of service with the Denver Police Department. Chen answered each question with clarity and precision. She had testified before. She knew the importance of every word, every gesture, every moment of eye contact with the jury. "Officer Chen," Blackwell said, "can you describe your training and experience with K-9 detection work?" Chen nodded. "I've been a certified K-9 handler for 11 years. Before that, I served as a patrol officer for 6 years. Duke and I have been partners for 8 years. He was trained from puppyhood in narcotic detection, specifically for the identification of cocaine, heroin, methamphetamine, and fentanyl." "And what is Duke's record of successful alerts?" 247 confirmed narcotics detections leading to arrests and prosecution, Chen replied without hesitation. "His false positive rate is less than 1%, which is significantly lower than the national average for K-9 units." Judge Mitchell's left eyebrow rose slightly. He made a note on his pad. "False positives, investigate further." In his mind, a 1% error rate meant that Duke had failed to correctly identify narcotics or had given false alerts in approximately 2 or 3 instances. While that might seem impressive to a jury, Judge Mitchell believed that in a system where a person's freedom and constitutional rights hung in the balance, a 1% error rate was entirely unacceptable. He had read studies, or at least he believed he had, suggesting that K-9 detection was subject to handler bias, that dogs could pick up on subtle cues from their handlers that directed them toward particular suspects or locations. He had constructed a narrative in his mind already. Officer Chen, whether consciously or unconsciously, was signaling to Duke where she expected to find drugs. Blackwell continued his direct examination, walking through the circumstances of the Wellington stop. He asked detailed questions about the vehicle, the initial reason for the stop, the observations that had prompted Officer Chen to request a narcotics detection dog. Chen described how she had approached the vehicle, how she had walked Duke around the perimeter of the car, and how Duke had immediately alerted at the driver's side door panel. "When you say he alerted," Blackwell asked, "what exactly does that mean?" "Duke has been trained to sit down when he detects narcotics," Chen explained. "He sits and maintains his focus on the location where he's detected the odor. It's a very distinct behavior. He doesn't bark, he doesn't paw at the vehicle. He sits and waits for me to acknowledge the alert." "And that's what happened in this case?" "Yes." Duke alerted to the driver's side door panel. Within 10 minutes, the vehicle had been searched, and the cocaine was discovered exactly where Duke had alerted. Judge Mitchell leaned back slightly in his chair. He had heard this testimony before in similar cases, and it always struck him as remarkably convenient. A dog who happened to alert, and then drugs were discovered exactly where the dog indicated. He was not in his own mind being unfair or biased. He was being skeptical. He was being rigorous. He was, he believed, protecting the interests of justice by demanding more convincing evidence than the word of a handler about her dog's behavior. When it came time for the defense attorney to cross-examine Officer Chen, the defense made an attempt to establish that Duke's alerts were unreliable, that they could be affected by handler bias, and that a dog's behavior was ultimately subjective and difficult for a jury to evaluate. But Chen was well prepared. She had been trained extensively in testifying, and she responded to each challenge with composure and detail. She described the scientific basis of canine olfactory capability, how dogs could detect odors at concentrations as low as parts per trillion, how their nasal passages contained approximately 300 million olfactory receptors, compared to humans' roughly 5 million. Judge Mitchell listened with what appeared to be interest but was, in reality, a kind of polite skepticism. He had heard similar claims about dogs' sense of smell before, and while he accepted that dogs could smell better than humans, he remained unconvinced that this translated to reliable courtroom evidence. He had built a career on precision, on evidence that could be measured and quantified, and the behavior of a dog seemed to him to fall into a gray area of subjective interpretation. By the time Officer Chen and Duke left the witness stand, Judge Mitchell had asked a series of pointed questions designed to establish the possibility of handler bias. the unconscious cues that Chen might have given Duke, and the difficulty in replicating or testing a dog's alleged detection capability under controlled conditions. His questions had been polite but pointed, and several observers in the courtroom recognized them as the questions of a judge who had essentially decided that the K9 evidence was unreliable. As Officer Chen led Duke back out of the courtroom, the dog passed directly in front of Judge Mitchell's bench. For just a moment, Duke's dark eyes met the judge's gaze. Duke did not growl or show any sign of aggression. Instead, he simply looked at the judge with what might have been described as quiet, patient intelligence, the look of a being who understands far more about human nature and character than he is able to express in human language. Then Duke turned and walked out with Officer Chen, his leash held firm, his purpose secure, entirely unconcerned with the skepticism of a federal judge. Judge Mitchell returned his attention to his notes, convinced that he had successfully identified a significant weakness in the prosecution's case. He had no idea that his skepticism was about to be tested in a way that would fundamentally challenge his assumptions about evidence, reliability, and the limits of human perception. The afternoon session of court began at 1:30 p.m., and Judge Mitchell returned to the bench after consuming a modest lunch in his chambers, a turkey sandwich, a small salad, and 2 cups of coffee. He felt energized and mentally sharp, prepared to continue dismantling what he considered to be a fundamentally flawed prosecution strategy. The case of United States v. Marcus Wellington had become, in his mind, a perfect opportunity to demonstrate his commitment to rigorous evidentiary standards and his refusal to be swayed by what he regarded as emotionally compelling but logically suspect testimony. Assistant U.S. Attorney James Blackwell stood and called his next witness, DEA Special Agent Michael Torres, a chemist with 15 years of experience in narcotics analysis. Torres was sworn in with the practiced efficiency of a witness who had testified in federal court dozens of times. He carried with him photographs, chemical analysis reports, and documentation of the chain of custody for the evidence seized from Marcus Wellington's vehicle. The testimony proceeded methodically. Agent Torres described the discovery of the cocaine, the procedures used to test and verify the substance, and the results of his analysis. The cocaine was confirmed to be 92% pure, an unusually high concentration that indicated professional-grade drug manufacturing and distribution. Torres presented the evidence with the clinical precision of a scientist presenting findings in a laboratory setting. His testimony was solid, undisputable, and entirely based on empirical analysis that could not reasonably be challenged. Judge Mitchell followed the testimony with careful attention, making notes about the chemical composition, the weight of the substance discovered, and the street value of the contraband. This was the kind of evidence that Judge Mitchell could appreciate, objective, measurable, and based on scientific methodology that had been tested and validated through decades of use in courtrooms across the country. When Blackwell finished his direct examination, Judge Mitchell had no questions for Agent Torres. The testimony stood on its own merits. However, when the defense attorney rose for cross-examination, they focused intensely on the timing of the evidence discovery and the procedures followed during the vehicle search. The defense suggested that the chain of custody documentation, while appearing thorough, contained gaps that could theoretically allow for alternative explanations of how the cocaine had come to be in the vehicle. It was a weak argument, the kind of technical challenge that rarely succeeded in court, but it represented the defense's primary strategy, not to dispute the evidence but to introduce reasonable doubt about its origins. Judge Mitchell interrupted the cross-examination at one point, posing a question directly to Agent Torres. Agent Torres, in your experience, is it common for individuals to transport narcotics in vehicle door panels? Torres nodded. Your Honor, it's extremely common. Door panels are a preferred hiding location because they're relatively easily accessed. They provide insulation from detection dogs. Judge Mitchell's expression shifted almost imperceptibly, but it was enough to suggest that Torr's comment about detection dogs had landed exactly where the judge wanted it to land. In the judge's interpretation, Torres had essentially admitted that drug traffickers understood the unreliability of K9 detection and took specific measures to circumvent it. To Judge Mitchell's mind, this supported his theory that K9 evidence could not be trusted. If narcotics could be hidden effectively enough to evade a dog's detection, then when a dog did alert, it might simply be responding to residual scents or handler cues rather than the actual location of significant quantities of drugs. As the afternoon wore on, Blackwell presented additional witnesses: the officer who had initially stopped Wellington's vehicle, the officer who had supervised the search of the vehicle, and a DEA analyst who testified about trafficking patterns in the Denver area that aligned with Wellington's profile and the nature of the substance discovered. Each witness presented evidence that incrementally strengthened the prosecution's case. Each piece of testimony was professional, credible, and difficult to challenge. But as each witness testified, Judge Mitchell made a particular effort to ask questions that subtly reinforced his skepticism about the K9 evidence. When a police officer testified, Judge Mitchell asked whether the officer had any independent observation that would have led him to suspect narcotics in the vehicle prior to the K9 alert. When the DEA analyst testified, Judge Mitchell asked whether narcotics of this quantity and purity could have been present in the vehicle without the owner's knowledge, a question designed to introduce reasonable doubt about Wellington's culpability. By late afternoon, as the prosecution began to wrap up its case, Judge Mitchell had essentially telegraphed his skepticism to everyone in the courtroom. He had been subtle about it. He had asked no improper questions, had violated no rules of judicial conduct, but his bias was apparent to anyone paying attention. The defense attorney, sensing the judge's predisposition toward acquittal, looked noticeably more relaxed. Even Wellington, who had appeared nervous and despondent during the morning session, now sat with an expression of cautious hope. When Blackwell stood to address the issue of the K9 evidence directly, he did so with the measured determination of a prosecutor who understood he was fighting an uphill battle against judicial skepticism. "Your Honor," he began, "the evidence in this case rests substantially on the alert provided by K9 Officer Duke. We understand that the court has expressed concerns about the reliability of K9 evidence, and we respect the court's rigorous approach to evaluating evidence. However, the law is clear that properly trained K9 units, with established records of reliability, are admissible as evidence. Officer Duke's record speaks for itself: 247 successful detections with a false positive rate of less than 1%. Judge Mitchell set down his pen and allowed a subtle smile to cross his face. He did not respond immediately. Instead, he let the silence in the courtroom stretch for a moment, a classical judicial technique designed to communicate disapproval without speaking words. "Mr. Blackwell," the judge finally said, his voice carrying an edge of professorial condescension, "I appreciate your presentation of the evidence. However, I must express my concern about the degree to which this prosecution relies on what amounts to the subjective interpretation of an animal's behavior. The fact that Officer Chen believes Duke has alerted to narcotics on 247 occasions does not necessarily mean that Duke's behavior is reliable evidence. It means that Officer Chen's interpretation of Duke's behavior has been consistent. There is a significant difference." The courtroom was entirely silent now. Judge Mitchell continued, "Furthermore, the fact that a drug trafficker chose to hide narcotics in a location that might evade K9 detection suggests, to me, that even those engaged in criminal activity understand the limitations of K9 reliability. If Duke's sense of smell were truly as remarkable as suggested, why would traffickers bother with such precautions?" Blackwell started to respond, but Judge Mitchell raised his hand. I will reserve judgment on the admissibility of the K-9 evidence until I have had time to review relevant case law on this matter. We will reconvene tomorrow morning at 9 o'clock. This court is adjourned." As Judge Mitchell rose and left the bench, he allowed himself a satisfied expression. He had, in his own mind, exposed a fundamental weakness in the prosecution's case. He had, through careful judicial examination, identified precisely the kind of evidentiary problem that rigorous judges were supposed to identify. He felt confident, intellectually superior, and entirely certain that his skepticism was not bias, but rather the proper application of judicial wisdom. He had no way of knowing that his certainty was about to be shattered by an animal whose abilities he had fundamentally underestimated. That evening, Judge Mitchell returned to his chambers and did something he rarely did. He conducted legal research on K-9 evidence without the assistance of his law clerk. He wanted to approach this independently, without Jessica Torr's inevitable pushback about his skepticism. He pulled several volumes from the legal reference section of his chambers and settled into his leather chair with a feeling of intellectual purpose. The case law, he discovered, was actually more ambiguous than he had initially assumed. While the federal courts had generally accepted K-9 evidence as admissible, there were a growing number of decisions that expressed concern about the absence of rigorous scientific standards for K-9 detection. Some judges had noted, much as Judge Mitchell had observed, that handler bias could potentially influence a dog's behavior. Other courts had commented on the difficulty of cross-examining a dog or establishing objective criteria for what constituted a reliable alert. Judge Mitchell felt vindicated by these readings. He had been correct in his skepticism. However, as he read further into the evening, he came across several studies conducted by veterinary behavioral specialists and canine cognition researchers that suggested the opposite conclusion, that dogs possessed olfactory capabilities so far beyond human understanding that they could reliably detect drugs even at trace concentrations, and that their behavior, while perhaps subjective in appearance, was actually based on concrete sensory input rather than handler cueing. One study, conducted at a major research university, had attempted to determine whether handler bias actually affected K-9 detection performance. The researchers had conducted blind trials in which handlers were not told where narcotics were actually located. The results showed that K-9 alerts remained remarkably accurate even when handlers had no expectation of finding drugs in particular locations. The study suggested that, contrary to the assumption that handler bias drove K-9 performance, dogs were actually responding to genuine olfactory detection. Judge Mitchell closed the legal volume and leaned back in his chair, feeling slightly less certain than he had been an hour earlier. But he did not allow this uncertainty to substantially alter his approach. He had already expressed his skepticism publicly, and he was not a man to reverse course easily. Instead, he rationalized the conflicting evidence. The studies could have been flawed, the handlers could have been unconsciously biased in ways that statistical analysis could not measure, and the entire field of K-9 detection existed in a gray area where emotion and intuition played too significant a role. By the time he left his chambers at 8:30 p.m., Judge Mitchell had resolved to maintain his skeptical stance. He would require the prosecution to present additional evidence beyond the K-9 alert. If the case rested primarily on Duke's detection, Judge Mitchell would be inclined to exclude that evidence or to instruct the jury that it should be viewed with considerable caution. The following morning, as attorneys and courtroom personnel began to arrive, something unusual happened. The defense attorney, a woman named Rebecca Morrison, who had been representing Marcus Wellington with professional competence but limited success, requested an immediate meeting with Judge Mitchell in chambers. Judge Morrison was a solo practitioner, representing Wellington on a public defender referral, and she had the harried expression of someone juggling too many cases with insufficient resources. Judge Mitchell, sitting behind his massive mahogany desk, gestured for Morrison to sit. "What is this regarding, Ms. Morrison?" "Your Honor," Morrison began, her voice carrying a note of careful calculation, "I have reviewed the court's concerns about the K-9 evidence, and I believe there is a way to address those concerns directly." Judge Mitchell's interest was immediately piqued. "Explain." "Your Honor has suggested that K-9 evidence is subject to handler bias, and that the dog's alert is essentially a subjective interpretation of animal behavior. I propose that we allow K-9 Officer Duke to undergo a blind detection test, conducted here in the courtroom, to demonstrate whether the dog's reliability remains consistent when the handler does not know where narcotics are located." Judge Mitchell felt his pulse accelerate. This was, he thought, a brilliant suggestion, precisely the kind of rigorous testing that should be applied to all evidence presented in federal court. It was also, in his estimation, a test that Duke would likely fail, thereby vindicating his skepticism and providing clear grounds for excluding the K-9 evidence entirely. "That is an interesting proposal," Judge Mitchell said carefully, "but it would be highly irregular. The prosecution would need to agree to such a demonstration." "I have already discussed it with Mr. Blackwell," Morrison replied. "He is willing to proceed, provided the court approves." Judge Mitchell's eyebrows rose slightly. This was unexpected. He would have assumed that a prosecutor, facing challenges to his evidence, would resist additional testing that might further weaken his case. That Blackwell had agreed suggested either profound confidence in Duke's abilities or a strategic calculation that Judge Mitchell could not immediately discern. "And what are the parameters of this test?" Judge Mitchell asked. "Officer Chen would be blindfolded," Morrison explained. "The prosecution would place sealed containers in various locations throughout the courtroom. Only the defense and the court would know which containers actually contain narcotics. Officer Chen and Duke would search the courtroom, and we would observe whether Duke alerts only to containers with actual narcotics, or whether he alerts to other containers as well, or to no containers at all. This would provide objective data about the reliability of his detection." Judge Mitchell leaned back in his chair, considering the proposal. It was, he had to admit, a clever move. By proposing the test himself, the defense had positioned themselves as champions of rigorous evidence evaluation, and from Judge Mitchell's perspective, the test seemed likely to demonstrate that Duke's abilities were not as reliable as the prosecution claimed, particularly when the handler could not unconsciously cue the dog about where drugs might be located. "I will allow this test," Judge Mitchell said, "provided that all parties agree to the parameters and that the test is conducted with appropriate documentation and observation. However, I want to be clear. This test will not replace the requirement for solid corroborating evidence in this case. A dog's performance on a courtroom demonstration, however impressive it might appear, does not necessarily translate to reliable evidence in the context of an actual criminal investigation." "Understood, Your Honor," Morrison replied. As she left his chambers, Judge Mitchell felt a curious mixture of satisfaction and anticipation. He had positioned himself as a judge committed to rigorous evidence evaluation, and he had allowed a test that he believed would expose the fundamental unreliability of K-9 detection. In his mind, the court system, with him as its guardian, was about to demonstrate its commitment to justice through skepticism and rigorous testing. He had absolutely no idea what was about to happen in his courtroom would fundamentally challenge everything he believed about the nature of evidence, expertise, and the limitations of human perception. That afternoon, as the courtroom filled with observers, reporters, and curious onlookers who had heard about the unusual demonstration, Judge Mitchell took his seat on the bench with the confidence of a man about to witness the vindication of his skepticism. He had no way of knowing that Duke, a dog he had already dismissed as an unreliable source of evidence, was about to teach him one of the most humbling lessons of his judicial career. The stage was set. The test was about to begin, and Judge Harrison Mitchell's certainty was about to meet an immovable object. The courtroom had transformed into something resembling a theater stage. The prosecution and defense had spent the better part of 2 hours preparing for the demonstration, arranging the logistics, and establishing the parameters that would govern the test. Judge Mitchell observed from his elevated bench with the demeanor of a scientist, preparing to witness an experiment, whose outcome he had already predicted with considerable confidence. 7 sealed containers, all identical in appearance, had been procured. They were white plastic cylinders, each approximately 6 inches tall and 3 inches in diameter, with secure lids that prevented any visual inspection of their contents. 5 of the containers held nothing but clean air and a small amount of baking soda, an innocuous substance chosen specifically to ensure that any odor emanating from the containers would be unrelated to narcotics. 2 of the containers held trace amounts of cocaine, just enough to constitute evidence, but not enough to create any risk to courtroom personnel. The placement of the containers had been determined by Rebecca Morrison, the defense attorney, in consultation with Judge Mitchell. The containers were distributed across the courtroom in a pattern designed to eliminate any possibility of spatial bias. 1 container sat on the judge's bench itself. Another rested on the defense table. 2 more were positioned near the jury box. 1 was placed on the prosecution table, and 2 others were set on small stands in the open space between the bench and the gallery. Officer Sarah Chen stood to the side of the courtroom, a black silk blindfold held in her hands. The blindfold had been examined by both the prosecution and defense to ensure it was genuinely opaque and would prevent any possibility of vision. Officer Chen's expression was calm, professional, and entirely confident. She had participated in similar demonstrations before, though never under courtroom conditions with a federal judge presiding. Beside her, Duke sat at attention, his posture erect, his dark eyes alert. Judge Mitchell leaned forward slightly, his fingers steepled beneath his chin. He had instructed the courtroom bailiffs to maintain absolute silence during the demonstration. He wanted no possibility of auditory cues that might direct Duke's attention toward particular containers. Every aspect of the test had been designed to be as rigorous as possible, not because Judge Mitchell was genuinely interested in proving Duke's reliability, but because he wanted to ensure that when Duke failed to perform, there would be no possible excuse offered by the prosecution. "We are ready to proceed," Judge Mitchell announced, his voice carrying the formal gravity appropriate to the moment. "Officer Chen, you will be blindfolded. Once the blindfold is secure, I will confirm that you cannot see. You will then conduct a search of the courtroom with K-9 Officer Duke. Duke will search for narcotics. We will document any alerts he provides. Is that clear?" "Yes, Your Honor," Officer Chen replied. The bailiff approached and carefully positioned the blindfold over Officer Chen's eyes, securing it firmly. Judge Mitchell rose slightly from his seat and observed as the bailiff ensured that Chen could not possibly see. Judge Mitchell waved his hand in front of Chen's face, and she made no reaction. "Officer Chen, can you see anything?" he asked. "No, Your Honor, nothing," Chen confirmed. Judge Mitchell nodded with satisfaction. The test was proceeding exactly as he had envisioned. He settled back into his chair and gave a subtle nod to indicate that the search could begin. Officer Chen reached down and grasped Duke's leash, a 6-foot lead made of braided leather that had been used in training exercises countless times. "Search," she commanded, her voice steady and professional. Duke's behavior changed immediately. The dog's already alert posture became even more focused, more intentional. His nose rose slightly, testing the air currents in the courtroom. He began to move with a deliberate, methodical gait that was entirely different from his ordinary movement. Every muscle in his body seemed dedicated to a single purpose, identifying the source of a particular odor. Judge Mitchell watched with the expression of someone observing a performance he had already anticipated and evaluated. He expected Duke to either show no reaction to any of the containers or to alert randomly at several containers, thereby demonstrating the unreliability of K9 detection when handler bias was removed from the equation. What happened next defied the judge's expectations entirely. Duke moved first toward the container that had been placed on the prosecution table. He approached it with deliberate steps, his nose working intently at the air immediately surrounding the sealed container. His pace slowed. His entire body language shifted into an intense focus. Then, without any visible cue from Officer Chen, whose vision was completely obscured, Duke sat down directly in front of the container and maintained his position, his dark eyes fixed on the location of the container, his body language communicating absolute certainty about what he had detected. The courtroom fell into a profound silence. Judge Mitchell's expression remained neutral, but his fingers had ceased their steepling and were now pressed flat against his bench, indicating a sudden shift in his emotional state. "Alert 1, announced Robert Santos, the courtroom clerk who had been designated as the official recorder of the test. "Container on the prosecution table. Time, 2:47 p.m. Duke remained sitting for 5 seconds longer, as if to communicate the absolute certainty of his detection, before Officer Chen gave a gentle command that allowed him to continue his search. The dog rose and resumed his methodical examination of the courtroom, moving toward the next location, a container positioned near the jury box. Again, the same sequence of events occurred. Duke approached the container, his nose working intently, his pace slowing as he drew closer. Then, with the same absolute certainty, Duke sat down directly in front of the container, his focus absolute, his body language communicating complete confidence in his detection. "Alert 2, Robert Santos announced. "Container near jury box, location B, time, 2:51 p.m. Judge Mitchell's jaw had tightened slightly. A part of his mind was constructing alternative explanations. Perhaps the blindfold was not genuine. Perhaps Officer Chen had somehow communicated through subtle means that the judge could not perceive. Perhaps Duke was responding to some form of environmental cue that had nothing to do with actual narcotics detection. But Duke continued his search with relentless precision. He approached each of the 5 containers that held only baking soda and air. At each one, he slowed his pace, his nose worked intently, and then he continued moving without alerting. He did not sit. He did not communicate detection. He simply moved on, his behavior making an unambiguous distinction between containers that held narcotics and containers that held nothing of interest. By the time Duke had completed his circuit of the courtroom, he had provided exactly 2 alerts, both to the containers that, unbeknownst to Officer Chen, held cocaine. "Your Honor," Robert Santos announced formally, "K9 Officer Duke has completed his search. 2 alerts provided. Both alerts correspond to containers containing narcotics. 0 false positives, 0 missed detections." Judge Mitchell remained absolutely silent. His face had paled slightly, and the muscles in his jaw were working as if he were grinding his teeth. The certainty he had felt only minutes earlier, the conviction that he was about to expose the fundamental unreliability of K9 evidence, had evaporated entirely. Rebecca Morrison, the defense attorney, maintained a completely neutral expression, though observers in the courtroom noted that her shoulders had relaxed slightly. The prosecution team had leaned back in their chairs with expressions of vindication, and Officer Sarah Chen, still blindfolded, allowed herself a small, satisfied smile that Judge Mitchell could not see, but that several jury members observed with considerable interest. Duke was led back to his position beside Officer Chen, his posture relaxed now that the task was complete, his dark eyes still alert but no longer focused with the intense concentration of the search. The dog appeared entirely unconcerned by the profound implications his performance had just demonstrated for everyone watching. Judge Mitchell removed his blindfold from Officer Chen's eyes with a gesture that seemed to require considerable effort. As the blindfold fell away and Chen's vision was restored, she turned to look directly at Judge Mitchell. For just a moment, their eyes met. Chen said nothing, but her expression communicated something that was impossible to misinterpret. A quiet, professional assertion that Judge Mitchell had been wrong in his skepticism. The judge's face had flushed a deep crimson. His hands trembled slightly as he picked up his pen, searching for something to write, some way to process what he had just witnessed. Judge Mitchell sat in absolute silence for nearly 30 seconds after the demonstration concluded. The courtroom had fallen into that particular quality of quiet that occurs when everyone present understands that something significant has just transpired, something that has fundamentally altered the trajectory of events. The judge's hands, which moments earlier had been poised with confident authority, now lay flat on his bench, palms down, as if he needed the physical contact with the solid wood beneath him to maintain his sense of equilibrium. Jessica Torres, his law clerk, watched her boss from her position at the side of the bench. She had known Judge Mitchell for 14 months, long enough to recognize the signs of internal distress masked by judicial composure. His jaw was clenched. A small muscle beneath his left eye was twitching almost imperceptibly. His breathing, which was normally controlled and measured, had become slightly shallow. These were not the physical manifestations of a man confident in his understanding of the evidence before him. Robert Santos, the courtroom clerk, sat with his hands folded in front of him, waiting for instruction. The bailiffs stood at their posts, maintaining the formal decorum that courtrooms required but with visible uncertainty about what should happen next. The jury members exchanged subtle glances, their entire understanding of the case suddenly realigned by what they had just witnessed. Several of them had noted, with the kind of careful observation that jurors in important cases develop, the moment when Judge Mitchell's confidence had faltered. They had observed the flush in his face, the sudden rigidity in his posture, the loss of the casual authority that had characterized his demeanor throughout the trial. Across the gallery, a local news reporter who had arrived that morning to cover the unusual case was rapidly making notes. This was precisely the kind of story that interested modern journalism: a federal judge confidently dismissing evidence, a dog asked to prove its reliability, and the unexpected reversal that followed. The reporter could already envision the headlines: Judge's skepticism shattered by K9 precision, or Federal Judge humbled by Police Dog's accuracy. Officer Sarah Chen had removed the blindfold completely and was standing calmly beside Duke, her hand resting on the dog's neck. She was not smiling triumphantly or displaying any sign of vindication, which only served to underscore the profound professionalism with which she had conducted herself throughout the demonstration. Her expression was composed, almost serene, the expression of someone who had known all along what the outcome would be, and who was simply allowing the reality to unfold as it inevitably must. Duke himself appeared entirely unconcerned by the implications of his performance. The dog sat at attention beside his handler, his dark eyes moving occasionally as he observed the people and the space around him. He had performed his function with absolute precision, and his canine understanding of events was likely limited to the satisfaction of having completed a task correctly and the expectation of receiving a reward, probably a favorite toy or treat, for his successful work. Judge Mitchell finally stirred. He set down his pen with deliberate care and leaned back in his chair. His eyes closed for just a moment, and when they reopened, they focused on the ceiling of the courtroom, the classical dome with its painted images of historical figures and the scales of justice. The judge seemed to be gathering himself, organizing his thoughts, attempting to construct a rational framework that would allow him to understand what had just occurred, and perhaps more importantly, to understand how his analysis had been so profoundly wrong. "I believe," Judge Mitchell finally said, his voice carrying a slightly hoarse quality as if his throat had tightened, "that we should adjourn for 15 minutes. All parties will remain available. We will reconvene at 3 o'clock. It was not a question or a suggestion. It was a judicial directive, and everyone in the courtroom immediately began to comply. Bailiffs moved toward the jury to escort them to the jury room. Attorneys began gathering their documents. The prosecution and defense team members exchanged glances, each side attempting to assess what the judge's sudden adjournment might portend. Judge Mitchell rose and walked from the bench, his robes moving behind him with less than their usual majesty. He disappeared into his chambers, and the heavy wooden door closed behind him with a click that seemed, to everyone present, to carry unusual significance. In his chambers, Judge Mitchell did something he had not done in years. He poured himself a glass of water with hands that trembled slightly. He sat in his leather chair and stared at his hands as if they belonged to a stranger. His mind was cycling through a series of realizations, each one more uncomfortable than the last. First, he had been wrong. This was the fundamental, inescapable fact. His skepticism about K9 evidence, which he had been convinced was intellectual rigor and careful judicial analysis, had actually been something else entirely: assumption, bias, and a failure to genuinely engage with evidence that contradicted his preconceived notions. He had constructed a narrative about why K9 detection was unreliable, and he had then selectively attended to information that confirmed that narrative while dismissing information that contradicted it. This was not judicial wisdom. This was human bias dressed in the robes of judicial authority. Second, he had been publicly wrong. He had expressed his skepticism openly in court, in front of jury members, attorneys, court personnel, and observers. Everyone present had heard him suggest that K9 evidence was unreliable, that handler bias was a determining factor in Duke's alerts, and that the prosecution's case was fundamentally flawed. And then, immediately after expressing those views with considerable confidence, he had witnessed Duke provide a flawless demonstration that disproved every assertion he had made. Third, and perhaps most painfully, he had been wrong in a way that appeared to be rooted in his own intellectual arrogance. He had dismissed Officer Chen's testimony, not because it was actually unreliable, but because his own conceptual framework had not allowed him to accept the possibility that a dog's sensory capabilities could be so far beyond human understanding that they constituted reliable evidence. He had essentially rejected evidence because it conflicted with his understanding of what evidence should look like. Fourth, and most troublingly, he had subjected a dedicated public servant, Officer Sarah Chen, to public skepticism and implicit accusations of bias based on nothing more than his own conceptual limitations. He had questioned her professionalism, her interpretation of her dog's behavior, and by extension, her character, in front of an audience that now included news media who would report on his dismissal of her testimony. Judge Mitchell stood and walked to the window of his chambers, which overlooked downtown Denver. The cityscape stretched before him, full of people going about their lives, unaware of the small but significant crisis unfolding in the federal courthouse. He could see the mountains in the distance, solid and permanent, and real in a way that his intellectual certainty had never been. He understood, with a clarity that was almost physically painful, that he had allowed his status as a judge, his position of authority, his years of experience, his reputation for careful legal analysis, to create a kind of cognitive shield that prevented him from genuinely engaging with evidence that contradicted his assumptions. He had been what modern psychology would call motivated reasoning at its finest, selectively interpreting information to confirm existing beliefs while dismissing contradictory evidence. And the most damning part of this realization was that he had done it all while genuinely believing he was protecting the integrity of the judicial system. A knock came at his chamber door. Jessica Torres entered without waiting for permission, which was her privilege as his law clerk. She carried a folder in her hands and had an expression that combined concern with something that might have been carefully suppressed satisfaction. "Judge," she said quietly, "I thought you should see something." She placed several research articles on his desk. Judge Mitchell recognized them immediately. The same studies about K9 olfactory capability and handler bias that he had read the night before. But Torres had highlighted passages, made notes in the margins, and had clearly conducted her own analysis since the court session began. "These studies," Torres said carefully, "consistently demonstrate that K9 detection, particularly with properly trained dogs like Officer Duke, actually does represent reliable evidence. The research on handler bias actually shows that it's not a determining factor when dogs are properly trained. I thought you should know that before we reconvene." Judge Mitchell looked at the research, then at his law clerk. "You disagreed with my skepticism," he said. "It was not a question." "Yes, Your Honor," Torres replied quietly. "I did, but I didn't feel I could say so without being insubordinate. Now I think you need to know." After Torres left, Judge Mitchell sat in silence once more. He understood that what he did in the next few minutes, how he responded to what he had just witnessed, would define not just this case but his character as a judge and as a human being. He could attempt to rationalize the demonstration, find technical flaws in how it had been conducted, use judicial authority to minimize its significance. He had the power to do all of those things. Or he could do something far more difficult. He could admit that he had been wrong. The clock on his chamber wall indicated that 10 minutes remained before he needed to return to the bench. Judge Mitchell sat with that knowledge, and with the weight of his choice pressing down upon his shoulders like a physical force. Judge Mitchell returned to the bench at precisely 3 o'clock. His face had regained some of its normal coloration, though observers noted that he appeared diminished somehow, as if the events of the afternoon had physically drained something essential from him. He settled into his chair with less of his usual commanding authority, and more of the careful deliberation of a man navigating uncertain emotional terrain. "The court has reconvened," Judge Mitchell announced formally. "I have reviewed the demonstration conducted with K9 Officer Duke, and I must acknowledge several important observations." The courtroom had become absolutely silent. Every person present, jury members, attorneys, court personnel, gallery observers, and news media, leaned forward slightly, understanding that Judge Mitchell was about to say something significant. "First," the judge continued, his voice measured and careful, "the demonstration conducted this afternoon was, from a procedural standpoint, rigorous and fair. K9 Officer Duke performed his detection with precision. He identified both containers holding narcotics and correctly distinguished them from containers holding no narcotics. This performance was conducted with Officer Chen's vision completely obscured, eliminating any possibility of handler bias in the manner I had previously suggested." Judge Mitchell paused, his fingers pressing against his bench. "Second, I must acknowledge that my previous expressions of skepticism regarding K9 evidence were, to some degree, based on conceptual assumptions rather than on rigorous evaluation of the actual evidence and research regarding K9 olfactory capability. This was an error in my judicial analysis." A subtle shift moved through the courtroom. Several jury members exchanged knowing glances. The defense attorney's shoulders had stiffened slightly. The prosecution team appeared to be processing this unexpected development with considerable caution. "Third," Judge Mitchell said, and his voice had taken on a quality that was almost pained, "I must acknowledge that my skepticism may have unfairly prejudiced this court against evidence that is, based on the demonstration I have just witnessed, demonstrably reliable. I do not believe this prejudice was intentional, but intent is not relevant to the outcome. The outcome is that I have potentially compromised the fair evaluation of evidence in this case through my own cognitive biases." Judge Mitchell removed his glasses and set them on the bench. Without them, his face appeared older, more vulnerable, more human in a way that his judicial authority usually obscured. "Therefore," he announced, I am denying my previous inclination to exclude K-9 evidence from this case. K-9 Officer Duke's alert, conducted under circumstances consistent with those he experienced during the original vehicle stop, constitutes reliable evidence. The prosecution's case stands on the basis of that evidence, combined with the chemical analysis testimony of Agent Torres and the testimony of the officers who conducted the vehicle search. The defense attorney, Rebecca Morrison, had begun to speak, but Judge Mitchell raised his hand. Ms. Morrison, I recognize that your client may have benefited from my previous skepticism toward the K-9 evidence. However, it would be unjust to allow my own errors in judicial reasoning to determine the outcome of a case. Justice requires that evidence be evaluated fairly, not that cases be decided on the basis of a judge's intellectual shortcomings. The jury was now instructed to proceed with their deliberations based on the totality of the evidence, with the K-9 alert given appropriate weight in the context of the other evidence presented. Judge Mitchell made it clear, through his careful language and his obvious discomfort, that he had changed his assessment of the evidence, and that he believed the prosecution had presented a compelling case. The jury was led out to the deliberation room. Judge Mitchell sat on his bench, his expression almost blank, as if the emotional intensity of the previous hour had exhausted his capacity for expression. The jury deliberated for 3 hours and 14 minutes. When they returned, the foreman stood and announced a verdict of guilty on all counts. Marcus Wellington, who had perhaps believed that Judge Mitchell's skepticism might result in acquittal, slumped in his chair as the weight of his conviction settled upon him. The defendant's public defender, working with limited resources and facing a judge who had essentially signaled his belief in the prosecution's evidence, had been unable to construct a compelling defense. As Judge Mitchell prepared to schedule a sentencing hearing, he made a statement for the record. Let it be noted that this court's previous expressions of skepticism regarding K-9 evidence were based on judicial error. The demonstration conducted this afternoon has demonstrated the reliability of K-9 detection when conducted by properly trained handlers and dogs. This court acknowledges its error and trusts that the jury has rendered a just verdict based on accurate evaluation of the evidence presented. It was an unusually explicit acknowledgement of judicial error, and everyone in the courtroom understood its significance. However, Judge Mitchell's acknowledgement of his error was only the beginning of the consequences that were about to unfold. Following day, the Denver Post published a front-page article titled "Federal Judge's Bias Against Police Dog Evidence Exposed in Dramatic Courtroom Demonstration." The article detailed Judge Mitchell's dismissive skepticism, his public expressions of doubt about K-9 reliability, and his subsequent reversal after witnessing Duke's flawless performance. Local television stations picked up the story, with reporters standing outside the federal courthouse and discussing the judge's apparent bias. Within a week, legal blogs and national news outlets had amplified the story. Law professors began writing opinion pieces about judicial bias and the dangers of judges allowing personal skepticism to influence their evaluation of evidence. The Colorado State Bar Association received a formal complaint about Judge Mitchell's conduct, specifically alleging that his expressions of skepticism about K-9 evidence constituted prejudgment and violated rules of judicial conduct that required impartiality. Judge Mitchell received a formal letter from the Colorado Supreme Court's Judicial Conduct Commission indicating that his conduct was under review. While the letter did not suggest that he had violated rules in a way that would result in removal, it indicated that his behavior had raised concerns about his ability to evaluate evidence without bias. The letter was not made public, but Judge Mitchell's secretary, Margaret, noticed that he spent an entire afternoon in his chambers after reading it, with the door locked. His colleagues on the federal bench, while maintaining professional courtesy, treated him differently. Several of them made subtle comments during judicial conferences about the importance of maintaining neutral evaluation of evidence. Judge Miranda Castellano, a judge he had considered a friend, made a point of telling him that she had read the newspaper articles and that these things happen to all of us eventually. Most painfully, perhaps, Judge Mitchell's reputation in the legal community began to shift. When he had previously been discussed by lawyers and other judges, he had been characterized as rigorous, careful, and intellectually demanding. Now, in conversations he did not witness but of which he became peripherally aware through colleagues' comments, he was being characterized as biased, arrogant, and willing to let personal assumptions override evidence. His invitation to speak at the Colorado Bar Association's annual conference was quietly withdrawn. A law review article he had submitted for publication was rejected by the editor with a note suggesting that the timing of its submission, coming so soon after the courtroom incident, made its publication inadvisable. Younger attorneys who worked in the federal courthouse began seeking opportunities to work with other judges, their career ambitions making them sensitive to the possibility that association with Judge Mitchell might affect their professional prospects. Judge Mitchell continued to preside over his docket. He continued to render decisions that were legally sound and carefully reasoned, but something fundamental had changed in how he approached evidence and how he understood his own role in the judicial system. Every time a case came before him that involved evidence he initially found questionable or that contradicted his preconceived notions, he found himself hesitating, recalling the classroom demonstration and the moment when his certainty had shattered. He began to read more extensively about cognitive bias, about the ways that human reasoning could be systematically distorted by assumptions and preconceived notions. He started to understand that his error had not been merely a momentary lapse in judgment, but rather a reflection of patterns in human thinking that affected everyone, including judges charged with the sacred responsibility of evaluating evidence fairly. 6 months after the trial of United States v. Marcus Wellington concluded, Judge Mitchell sat in his chambers one evening and drafted a speech. The speech was titled "On the Dangers of Judicial Certainty," and in it, he described, without explicitly naming the case, how he had allowed his own intellectual certainty to cloud his judgment. He described how he had convinced himself that skepticism was wisdom when it was actually arrogance. He described how he had allowed a position of authority to create a shield that protected him from genuine engagement with evidence. But Judge Mitchell did not deliver the speech publicly. Instead, he sent it to the Colorado State Bar Association's Judicial Education Program, with a request that it be included in the annual continuing legal education requirements for judges. His hope was that his error, and his recognition of that error, might serve as a cautionary tale for other judges who might otherwise fall into similar patterns of biased reasoning. The Bar Association accepted the speech and incorporated it into their judicial education materials. And Judge Harrison Mitchell, the federal judge who had laughed at a police dog and then been humbled by that same dog's performance, returned to his bench each morning with a changed understanding of what justice required. Not the confident application of personal certainty, but the humble willingness to evaluate evidence fairly, even when that evidence contradicted his assumptions about how the world should work. 2 years had passed since the courtroom demonstration that had fundamentally altered Judge Harrison Mitchell's understanding of himself as a jurist and as a human being. The case of United States v. Marcus Wellington had long since concluded, with Wellington serving his sentence in a federal penitentiary in Colorado, his appeals exhausted, his legal options depleted. The narcotics that Duke had detected with such precision had been processed as evidence, destroyed according to federal protocol, leaving no physical reminder of the events that had transpired except in the memories and official records of those who had participated. Yet the reverberations of that afternoon continued to expand outward in ways that neither Judge Mitchell nor anyone else present in the courtroom could have fully anticipated. Officer Sarah Chen and K-9 Officer Duke had become minor celebrities within law enforcement circles and among dog training communities. Chen had been invited to present at national conferences on K-9 detection and handler training. Her department had received increased funding for their K-9 unit, approved by city council members who had read news articles about Duke's remarkable performance. More significantly, other police departments across the country had begun to review their own K-9 programs with renewed interest, and several departments that had previously considered their K-9 units to be supplementary resources had elevated them to central positions in their investigative protocols. Duke himself, now 9 years old and entering the final years of his working life, had become something of a canine legend. He had appeared in a documentary about police dogs that had been broadcast on a national streaming service. Elementary school children in Denver had been shown videos of his courtroom demonstration as part of their education about working animals and the capabilities of different species. T-shirts bearing Duke's image had been sold at police department fundraising events. More importantly, Duke's performance had contributed to a subtle but significant shift in how courts across the country evaluated K-9 evidence. A shift toward greater respect for the capabilities of properly trained dogs, and a corresponding reduction in the kind of reflexive skepticism that Judge Mitchell had exemplified. Judge Mitchell himself had experienced a transformation that was both professional and deeply personal. His speech on judicial certainty, incorporated into Colorado's Judicial Continuing Education Program, had become required reading for all judges in the state seeking to maintain their judicial licenses. Legal journals had republished portions of the speech with commentary from law professors and judicial ethics experts. An article in a prestigious legal review had examined Judge Mitchell's case as a cautionary tale about the dangers of allowing intellectual confidence to override empirical evidence. But the professional recognition of his error, while intellectually validating, was not where the deepest transformation had occurred. The deepest transformation had happened quietly, in the daily practice of his judicial work, in the moments when he encountered evidence that contradicted his assumptions and found himself pausing, reconsidering, remaining open to possibilities he might otherwise have dismissed. Judge Mitchell had also undertaken personal research into the nature of judicial bias and cognitive error. He had read extensively in the field of cognitive psychology, learning about concepts like confirmation bias, motivated reasoning, and the backfire effect, the tendency for people to cling more firmly to beliefs when presented with contradicting evidence. He had come to understand that his error with Judge Duke's evidence had not been an anomaly, but rather an illustration of systematic patterns in human thinking that affected not just him, but every person tasked with evaluating evidence and rendering decisions. This understanding had made him a different kind of judge. He was more careful in his preliminary assessments of evidence. He was more willing to acknowledge uncertainty. He was more likely to seek out information that contradicted his initial impressions rather than information that confirmed them. His judicial decisions, while remaining intellectually rigorous, had acquired a quality of genuine intellectual humility that had not been present before. Lawyers who appeared before him began to notice the change. Some of them appreciated it. Young attorneys, in particular, seemed to respect the judge's willingness to genuinely engage with arguments that challenged his initial thinking. Others found it frustrating. Litigators who had previously been able to predict Judge Mitchell's reactions with some confidence now found him more unpredictable, more willing to be moved by arguments he might previously have dismissed. One afternoon, approximately 2 years after the Duke demonstration, Judge Mitchell received an unexpected visitor in his chambers. Officer Sarah Chen entered, accompanied by Duke, who was now noticeably graying around the muzzle, his movements slightly less energetic than they had been during his courtroom performance. The dog had been retired from active duty 6 months earlier, after 8 years of service, and was now spending his declining years in comfort with Officer Chen's family. "Judge Mitchell," Chen said, her demeanor professional but warmer than it had been during the trial, "I hope this isn't an intrusion. I wanted to bring Duke by before we left Denver. I've been transferred to a new assignment in California, and this was an opportunity to say goodbye properly." Judge Mitchell stood immediately. For a moment, he seemed uncertain how to respond, as if the encounter with the dog and officer who had so profoundly affected his life brought up emotions he had not fully processed. "Officer Chen," he finally said, "I'm grateful you came. I've wanted to apologize for my conduct during the trial. My skepticism toward your testimony and your dog's capabilities was unfair and was rooted in my own intellectual assumptions rather than in any genuine evaluation of the evidence." Chen smiled slightly. "I appreciate that, Judge, but I want you to know that your response afterward, your willingness to acknowledge the error publicly, meant more than any initial skepticism could have harmed. It showed that you were committed to justice over ego. That's rare." Duke approached Judge Mitchell and nudged the judge's hand with his nose, a gesture of greeting, nothing more, but one that Judge Mitchell found emotionally significant. He stroked the dog's graying head, feeling the warmth of the animal beneath his hand, and felt something that might have been genuine gratitude. After Chen and Duke left his chambers, Judge Mitchell sat for a long time in the silence of his office. He thought about the trajectory of events that the dog had set in motion, the public humiliation, the complaints to the Judicial Conduct Commission, the articles in legal journals, the speech on judicial certainty, and finally, this quiet moment of reconciliation with the officer and dog who had inadvertently taught him one of the most important lessons of his life. He thought about how arrogance, dressed in the language of intellectual rigor, had nearly caused him to render an unjust decision. He thought about how his position of authority had initially shielded him from genuine engagement with evidence that contradicted his assumptions. He thought about how a dog's simple, direct demonstration of its own capabilities had accomplished what no amount of argument or persuasion could have achieved. It had broken through his certainty and forced him to see himself as he actually was, a human being subject to the same cognitive limitations and biases that affected everyone. Over the following months, Judge Mitchell made several significant changes to his judicial practice. He began to require that any case involving evidence he found initially suspect or counterintuitive be given additional time for careful consideration. He instituted a practice of explicitly documenting his reasoning when he ruled against evidence or testimony, creating a record that would allow him to review his own thinking and identify any patterns of bias. He became more likely to recuse himself from cases where he recognized a potential bias, even when such recusal was not legally required. These changes were subtle, not the kind of dramatic reversals that would make headlines, but they reflected a fundamental shift in how Judge Mitchell understood his responsibility as a jurist, not to impose his intellectual framework on evidence, but to evaluate evidence fairly, even when that evidence challenged his assumptions about how the world worked. Years later, as Judge Mitchell approached retirement, the case of United States v. Marcus Wellington remained the defining moment of his judicial career, not because it had involved a spectacular legal principle or a landmark decision, but because it had taught him something far more valuable: that wisdom, in the practice of law and in the conduct of human life, required the humility to acknowledge when you were wrong, and the courage to change course accordingly. And K-9 Officer Duke, living out his retirement years in California with Officer Chen's family, had no awareness of the impact his courtroom performance had created. He existed in the simpler realm of a working dog who had done his job well, received his treats and praise, and had moved on to the next task. But for everyone who had witnessed his demonstration, Duke represented something more: a living reminder that sometimes the most important lessons come not from human expertise or intellectual authority, but from the simple, direct truth of observable reality, a truth that can shatter certainty and, if we are humble enough to listen, remake us into better versions of ourselves. Judge Mitchell's legacy would ultimately not be measured in the number of cases he had decided or the legal principles he had articulated, but rather in the example he had provided of a person in a position of power who was willing to admit error, to learn from that error, and to allow that learning to fundamentally transform how he approached his work and his life. It was a legacy born not from his certainty, but from his willingness to surrender it. The end.